Hello and welcome to the Minimum Competence episode for Thursday, August 8th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have a federal judge reducing attorney fees in the Google incognito case, Thomas Girardi's hidden $53 million settlement, Delta's inadequate refunds after an outage, the FCC's AI political ad rules dispute, and Ripple's $125 million penalty. Let's remember, it's better to be a good sport than a good winner, and read today's legal news. On this day in legal history, August 8th, 1974, President Richard Nixon announced his resignation from the office of the President of the United States, becoming the first and only president so far to do so.
Therefore, I shall resign the presidency effective at noon tomorrow. Vice President Ford will be sworn in as president at that hour in this office.
This unprecedented event followed the Watergate scandal, a complex political affair that began with a break-in at the Democratic National Committee headquarters and led to a series of revelations about abuses of power by the Nixon administration. Facing almost certain impeachment by Congress on charges of obstruction of justice, abuse of power, and contempt of Congress, Nixon chose to resign rather than prolong the national crisis. In his televised resignation speech, Nixon acknowledged that he no longer had a sufficient political base in Congress to continue effectively governing. He expressed regret for any injuries caused by his actions and highlighted his achievements while in office, yet he did not admit to any wrongdoing in the Watergate affair. Vice President Gerald Ford was sworn in as president on August 9th, 1974, and later granted Nixon a full pardon for any crimes he might have committed against the United States while in office. Nixon's resignation marked a significant moment in American legal and political history, underscoring the constitutional processes in place to address presidential misconduct. It also led to reforms aimed at increasing transparency and accountability in government, such as the Ethics in Government Act and amendments to the Freedom of Information Act. This event reshaped public trust in the presidency and highlighted the importance of upholding the rule of law at the highest levels of government. A federal judge indicated that the attorneys in a class action lawsuit against Google over Chrome's incognito mode are unlikely to receive their full $217 million fee request. During a hearing in Oakland, Judge Yvonne Gonzalez-Rogers also showed skepticism towards Google's proposal to cut the plaintiff's attorney fees by 25%. She criticized Google's legal team for suggesting she personally review thousands of timesheet entries. The case, which began 4 years ago, was settled in April, with Google agreeing to delete billions of records from incognito mode users and make some reforms, but without providing monetary damages to users. The plaintiff's attorneys from firms including Boyes, Schiller, Flexner, LLP claimed their fees were justified by 78,880 hours of work and sought a lodestar multiplier of 3.5, bringing their total request to $217 million. Judge Rogers commented that she rarely awards multipliers above 3 and noted the case's partial success. Google's attorney, Andrew Shapiro, argued that the plaintiff's fees were excessive, pointing out that Google spent only $40 million on the case. The lawsuit, initially filed in 2020, alleged that incognito mode improperly retained user data despite claims of privacy. The settlement requires Google to clarify data collection practices and allow incognito users to block third-party cookies for 5 years. Individuals can also seek monetary damages in California's state court. The plaintiffs originally sought $9 billion in damages, but Google's attorney argued that the final settlement warranted a lower fee due to its limited success. The case is Brown v. Google, LLC. Thomas Girardi concealed a $53 million settlement from a young man, Joseph Rugomez, whose home exploded, and misled him about the fund's status, a Los Angeles federal jury heard. Rugomez and his family, receiving inconsistent interest payments, repeatedly asked Girardi for settlement details after their 2013 agreement with Pacific Gas and Electric, but Girardi never complied. Girardi claimed he held the funds for Rugomez's protection, citing his youth and alleged drug dependency, though Rugomez clarified he was on narcotics for pain management due to extensive medical procedures. During the trial, the defense presented numerous financial documents, while the prosecution did not clarify the annuity terms or the full distribution of the $53 million settlement, which included a $25 million annuity and a $12.7 million legal fee. Kathleen Rugomez, Joseph's mother, testified that she only learned of the full settlement amount 2 years later and didn't suspect the discrepancy initially. She later sued Girardi with the help of Robert Finnerty, a former Girardi-Keese lawyer. Girardi faces charges of wire fraud for allegedly stealing $15 million in settlement funds meant for clients. He pleaded not guilty, with prosecutors claiming he delayed payments under false pretenses. Girardi, who avoided disciplinary action despite over 200 misconduct complaints, also faces fraud charges in Illinois federal court and multiple civil lawsuits. His firm, Girardi-Keese, went bankrupt in 2020. Girardi's mental competency to stand trial is contested, yet he was seen taking organized handwritten notes during the proceedings. The case is USA v. Girardi, and it is in the Central District of California. Delta Airlines, Inc. is facing a proposed class action lawsuit following a software outage on July 19th caused by CrowdStrike, which led to widespread flight delays and cancellations. The lawsuit filed in the U.S. District Court for the Northern District of Georgia claims that Delta failed to adequately refund passengers or provide the promised meal, hotel, and transportation vouchers. Instead of issuing refunds, Delta allegedly offered e-credits without informing passengers of their legal right to cash refunds, resulting in many passengers accepting the e-credits. The plaintiffs argue that Delta did not fulfill its commitments to passengers affected by cancellations within the airline's control, leading to breaches of contract, fraud, unjust enrichment, and violations of state consumer protection laws. They are seeking class certification and damages representing all passengers whose flights were canceled between July 19th and July 31st, with specific subclasses for California, Colorado, Florida, and Washington state. The CrowdStrike software update that caused the outage disrupted millions of devices using Microsoft Windows, impacting thousands of flights globally. Delta, the official airline of Team USA, struggled particularly hard, affecting nearly 2,000 athletes and staff traveling to Paris for the Olympics. While other airlines recovered quickly, Delta continued to cancel flights into the following week, even though they announced normal operations by July 25th. The U.S. Department of Transportation is investigating Delta's response to the glitch after receiving 3,000 complaints from passengers. Delta has declined to comment on the lawsuit, which is being handled by Webclase and Lehman LLC and Sauder Shellkopf LLC. The case is Barra v. Delta Airlines, Inc. The FCC's proposed rules for disclosing AI-generated content in political ads on radio and television have sparked a jurisdictional dispute with the Federal Election Commission. The FCC's rules, announced on July 25th, would require broadcasters to announce when AI is used in political ads. FCC Chairwoman Jessica Rosenworcel emphasized the need for voter transparency, comparing the requirement to existing rules about disclosing ad sponsors. Supporters, including AI regulation advocates, see it as a positive step amidst increasing deepfake use in campaigns. However, critics, including the FCC's 2 Republican commissioners and their FEC counterparts, argue that regulating political disclosures should fall under the FEC's jurisdiction. The proposed FCC rules, now open for public comment until September 4th, face uncertainty about whether they can be finalized before the upcoming election. This uncertainty is compounded by the U.S. Supreme Court's decision in Loper Bright Enterprises v. Raimondo, which limits federal agencies' regulatory powers. The FEC had already been considering similar AI content regulations since last year and recently sought public input on deepfakes in political ads. FCC critics argue that the FCC's efforts overlap and potentially conflict with the FEC's authority. Democratic FEC Vice Chair Ellen Weintraub, however, supports the FCC's initiative, suggesting that both agencies can complement each other. Despite the challenges, proponents believe the FCC's move will raise public awareness about AI in political ads, though the timeline for finalizing these rules remains unclear. The case's complexity is heightened by the evolving legal landscape and potential challenges to the FCC's authority following recent Supreme Court rulings. Ripple Labs has been ordered by a Manhattan court to pay the U.S. Securities and Exchange Commission, or SEC, approximately $125 million in penalties for the improper sale of XRP tokens. This decision follows the SEC's lawsuit against Ripple, CEO Brad Garlinghouse, and co-founder Chris Larson, accusing them of raising over $1.3 billion through an unregistered securities offering by selling XRP. Although the SEC initially sought $2 billion in fines and penalties, the court's ruling resulted in a significantly lower amount. The SEC had dropped its claims against Garlinghouse and Larson in October, but the case remained significant as one of the largest enforcement actions in the cryptocurrency sector. Ripple CEO Brad Garlinghouse acknowledged the court's decision, expressing respect and a commitment to continue the company's growth. The SEC emphasized that securities laws apply to investment contracts irrespective of the technology or labels used. This ruling marks a critical moment in the regulation of cryptocurrency sales and enforcement of securities laws within the digital asset space. By way of very brief background, the determination of whether a cryptocurrency qualifies as an investment contract is pivotal in deciding its classification as a security. The central question hinges on the application of the Howey test, which examines whether an investment is one of money in a common enterprise with the expectation of profits primarily derived from the efforts of others. If it is, it constitutes an investment contract. If a cryptocurrency meets these criteria, it falls under the regulatory purview of securities laws, that is, it is a security, and it is significantly impacted in its issuance and trading. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the biggest trouble with success is that its formula is just about the same as that for a nervous breakdown.